stipulation of probable cause.
Your Honor, no objection to the prosecutor's exhibits, and defense would be stipulating to probable cause.
All right, thank you. Prosecutor, once you enter first the items for pretrial detention, then items regarding the VOM.
Thank you, Judge. The state would submit S1, the certification in support of pretrial detention, and rely upon the grounds as set forth therein. The state would also submit S3, the complaint, specifically the affidavit of probable cause, and S4A and S4B, both the police report and arrest report in support of probable cause. And then the state would also submit and rely upon S2, the PSA, and S5, the CCH. And in regard to the motion to revoke release, Your Honor, the state would respectfully submit SV1, the certification, SV2, the violation of monitoring report, SV3, the release order, SV4, the prior PSA, and SV5, the prior complaint.
Thank you. All those are deemed in evidence. The court has reviewed S1, the certification, E-courts. The court will find the motion for pretrial detention has been properly filed in this matter, as well as the violation of monitoring and motion to revoke. Regarding the eligibility for detention, it is alleged the underlying matter involved an act of domestic violence. It's also alleged there's a serious risk that the defendant will not appear in court as required. The defendant will pose a danger to another person or the community, and/or the defendant will obstruct or attempt to obstruct justice or threaten, injure, or intimidate, or attempt to threaten, injure, or intimidate a prospective witness or juror. Eligibility has been established, and the state's in agreement with the eligibility as set forth in their S1. Mr. Lake had indicated he heard and understood the detention rights, which I read earlier, so we're going to move to the issue of probable cause. However, his attorney did indicate for purposes of this detention hearing only, she'll stipulate to probable cause, and this court has reviewed the state's items in evidence regarding probable cause, underscoring the complaint, the affidavit of probable cause, and the police report as well. The court will find that probable cause has been established for purposes of this detention hearing. However, there's still a rebuttable presumption against detention. I'll hear at this time the reasons why the state is seeking detention, then I'll hear reasons for his release by his attorney, and both the attorney and prosecutor could address the violation of monitoring issues. Prosecutor, you can proceed at this time.
Thank you, Judge. On October 10th, officers responded to a residential area in reference to a disturbance. Upon arrival, officers located this defendant in the woods behind the address of his girlfriend. Both parties stated that nothing occurred at that time and they were watching movies. However, on scene, officers learned that this defendant had an active restraining order against him from victim initials RT and is barred from that residence in which the disturbance occurred. The defendant was advised of this and acknowledged that he knew about the restraining order, and therefore officers remained in the area to maintain visual on the residence. And while staying in that area, officers observed a person wearing a gray hoodie matching the same clothing description as this defendant from the prior contact in the backyard. Upon approach, officers lost visual of the defendant, so they continued to stay in the area. Then the officers did see this defendant in the backyard of the barred against residence and approached him and was able to identify him as this defendant. Officers advised this defendant to stop. However, he ran off into the woods. But after a short pursuit occurred, the defendant finally gave himself up. He was placed under arrest, and the officers noted while being placed into that patrol car, he began yelling very loudly. And then while at police headquarters, this defendant removed his boot and struck the officer in the leg. So, Your Honor, the defendant was subsequently charged with 1 count of DP contempt, 1 count of DP resisting arrest, and a 4th-degree aggravated assault on law enforcement, which is a violent charge. The state is very concerned with this defendant's PSA. He scored a 6 on the new criminal activity scale, which is the highest number on that scale. His new violent criminal activity flag is raised, and he's a recommended no release. At the time of these new offenses, the defendant had 3 pending charges, which included a DP contempt, a 4th-degree resisting, and a 4th-degree criminal mischief. Judge, he was on level 2 pretrial monitoring at this time, and this would be the charges that are at the motion to revoke argument. But I just wanted to note for this argument that he was arrested on October 6th on these new charges. On the old pretrial monitor charges, and then not but 4 days later, on October 10th, he picked up these new charges. The defendant has 2 prior DP convictions, including a lewdness charge and a DV-related simple assault charge that occurred in 2022 and 2023. He also has 4 prior indictable charges, which include a 3rd-degree burglary, a 4th-degree criminal mischief, and a 3rd and 4th-degree aggravated assault on law enforcement. The 2 aggravated assaults and the simple assault represent 3 prior violent convictions this defendant has incurred. He also has 3 prior sentences to incarceration of 14 days or more. Judge, he's also currently on probation and violated these conditions with these new charges. He is on probation for the aggravated assault on law enforcement officer, and that probation began in 2024. This defendant has proven time again that he's a danger to the community, specifically those who live in this neighborhood where this barred against residents is. He constantly engages in criminal behavior, and most of these convictions and charges stem from that neighborhood. It's the state's position that no amount of pretrial monitoring could prevent him from obstructing justice or from being a danger to the community. Again, Judge's old charges were on October 6th, and he picked up these new charges not 4 days later. The state would also note that many of his charges include assault on law enforcement, which also is included in his recent resisting arrest. The defendant did score a 4 on the failure to appear scale. And although the PSA only reflects 1 failure to appear that is older than 2 years, the state is concerned by this defendant's blatant disregard for both pretrial monitoring conditions, for probation conditions, and for restraining order conditions. So in conclusion, Judge, the defendant scored a 4 on the failure to appear scale, a 6 on the new criminal activity scale, which is the highest score. His red flag is raised for new violent criminal activity, and the PSA recommends no release. He was on probation at the time of the new charges, and he was on pretrial monitoring at the time of these new charges. So therefore, Judge, the state would respectfully request you not deviate from the PSA recommendation of no release and detain the defendant pending trial. Unless Your Honor has any questions, the state would be prepared to move to their motion to revoke.
You can move to the motion to revoke.
Thank you, Your Honor. On a complaint warrant 2025-342-1505, as stated on October 6th, the defendant was charged with 1 count of 4th-degree criminal mischief, 1 count of 4th-degree resisting, and 1 count of DP contempt of a domestic violence order, and 1 count of PDP harassment. He was ultimately released on level 2 pretrial monitoring on October 7th, which was in line with his PSA at the time. However, as indicated as a violation of monitoring, he violated the conditions of his pretrial release. Specifically, he committed new offenses during his period of release, which were these new charges that were involved in this pretrial detention hearing. Again, it was a 4th-degree aggravated assault on police officer, another DP contempt of a domestic violence restraining order, and a DP resisting arrest. He also did not follow the no contact provision of his pretrial release. While he was on release, he made contact with the victim in the matter. He was also at the residence in the backyard in which he was barred from. He's not only barred from that residence on the no contact provision of his pretrial monitoring, but he's also barred from that residence due to active restraining orders against him. So he did not follow the pretrial monitoring or the restraining order conditions. He also did not follow the no return to scene conditions of his pretrial release. Again, Judge, he committed these new defenses. He was on the scene. Not only is there no return to scene, but there's also restraining orders against him. So giving his blatant disregard of pretrial monitoring and restraining order conditions, and that his PSA for his new charges recommend no release and has a red flag raised, the state believes that this defendant will not be compliant with pretrial monitoring conditions and is a danger to the community and an obstruction risk. He has shown on numerous occasions as he continues to pick up new charges that involve the same area of our community. He also shows that no amount of conditions can be imposed in order to uphold the triad. So for those reasons, Judge, the state would respectfully request you revoke this defendant's release. The state would also ask this court to find the violation of monitoring. Unless this court has any further questions, the state would submit.
I don't. Ms. Adams, I'll hear from you in both areas.
Thank you, Your Honor. Your Honor, this is a family issue, a family case. The victim in this case is my client's stepfather, and the home in question has been my client's home all his life. So at some point, his mother got remarried, and this is the gentleman that has moved into my client's home, his childhood home, his family home. So my understanding is that the stepfather obtained a temporary restraining order after an incident, and unfortunately, my client didn't have anywhere to go. So he was not on the actual property, but he was in the woods behind his home. So it was public property, but it was not the exact the residence that he was in. He was residing in a tent. My understanding was that the stepfather was going to drop the temporary restraining order, which my office has confirmed with him that he has since dropped the restraining order, and that he would like Mr. Lake to return to the residence. He indicated that he is not afraid of him. So with that understanding that my client was behind the home in a public area in the woods in a tent, as he was removed from his childhood home and his family, and that was the option that was available to him at the time. He indicated that he went to the door to ask his mother to charge his cell phone because he didn't have accessibility to a charger, and that was considered the violation. But understanding my client should have found other accommodations so as not to be in violation of the court's order, but it was his understanding that not being on the exact property and being on public property in a tent would have complied with those provisions of the release conditions. Again, this is a family situation. The family is coming together behind Christopher. They are asking that he can, or the victim, his stepfather, is indicating that he can return home. As I indicated, he is a lifelong resident of Ocean County. This is his home. He completed the 11th grade in Bayville Central Regional School District. He does work construction jobs for a company called DeVetto. He does recognize that he has some underlying anger management issues and some substance abuse. He has gotten treatment in the past at Agape Counseling and did successfully complete that about a year or so ago. 2.5 years prior, he did do an IOP through Agape. They do also address the anger management issues. He has continued to attend NA and AA as alcohol is his underlying issue. Unfortunately, the incident that did precipitate the TRO did involve that alcohol use, and he does recognize that he does need that additional treatment. The family is in support of him getting that treatment and returning to the home so that they can be a support for him. He does have aunts and uncles, 4 aunts and 5 uncles, and numerous cousins that are all supportive of him. He does have a fiance who is also a additional support in his life, Your Honor. And he does understand that he is on probation, and all of these new charges do represent a violation of that probation. I do believe that there might be a hold on him, a VOP hold.
Yes, yes.
We have discussed that even if Your Honor releases him on this case, that he does have to address that violation of probation. But this is his home, Your Honor. This is his family. Did he not address it in the most appropriate way by residing in the woods? Absolutely. If released, he could go home, but if the court is so inclined as to put a continued no contact provision and no return to the scene, he will be finding accommodations outside of the family residence with the assistance of that family. So unfortunately, the family did find themselves in this. He does want to address those substance abuse issues, Your Honor. Conditions of release that would ensure that would be a task evaluation, a substance abuse evaluation, and continued anger management. As I indicated, he has previously done that at Agape, and he is open to both addressing the substance abuse and the anger issues that have brought him before Your Honor today. And with that, defense would submit that there are conditions of release that would ensure the broader community's safety as the family is addressing the issues that have brought them to Your Honor today. And with that, defense would submit.
All right, thank you. I do have some questions for the prosecutor based on some statements made by Ms. Adams. Now, the police report indicates that he was in the wood area behind the address where he was barred from going. And then it appears at some point in time, he may have gone on that property after acknowledging he should not be there, may have been to have his phone charged. I just want to know, the woods behind the house is not on the barred property, prosecutor?
Judge, to the state's knowledge, I'm not sure exactly where he was on that property. I do know that the police were on scene because to respond to a call of disturbance. Now, who called? If I don't have that information to me right now, Judge. And it seems that they were speaking to him, as indicated in their narrative, in the backyard. So I'm not too sure exactly where the zoning or property line runs there.
But let me stop you there. But if he's in the backyard, he's on the precluded property. Is that correct?
That's my understanding, Judge. Yes.
Okay.
Your Honor, I can address that if the court.
Yeah, no, I'll let you get in, but I thought he went there to have his phone charged, which was for judgment. But go ahead. So,
Your Honor, he initially was not on the property.
Okay.
He was in the woods. My understanding is that there was a neighbor that called to report that he was residing in the woods in a tent.
Okay.
And when he saw the police come to the property, then he came up to the police to engage with them. I do see my client has his hands up. If Your Honor wants him to explain,
I don't want him to talk about the facts.
So that's my understanding. He was residing off of the property on public land in the woods. And when the police did arrive on scene, he was there with his fiance. Both of them did make their way to the property and engage with the police.
But you did make some indication that he went to speak to his mother about having his phone charged.
Correct. I do believe there were several, the prior violation of that no contact order. One of the charges was that incident when he did go to the house to have his phone charged.
But it's not the same day as this incident?
I don't believe so, Your Honor. The October 6th contempt may have been when he went to get his phone charged. And then the October 10th incident was when the police were called and he was in the woods and then made his way to the property when they arrived on scene.
And for the record, Your Honor, that October 6th contempt, the mother did call to report that he was back inside the residence. It wasn't. So at that time, it's indicated to me that, that's in clear violation of an active TRO.
Correct.
But you say he went there to get the phone. I'll give you a moment to speak to your client.
Thank you.
And if you want to clarify anything, and then I'll see about rendering my decision.
Thank you, Your Honor.
And did you address the bomb, Ms. Adams?
Your Honor, I would incorporate my arguments. I do understand that he did enter the property, so we would submit to that, Your Honor.
Okay. All right. Thank you. All right. I'll give you a chance to speak to your client.
Thank you.
Come back, and then I'll render my decision. Thank you. There's 3 violent offenses, and I give light to moderate weight to that. To his credit, he's never failed to appear in the past years older than 2 years. 1, and I give light weight to that. He has served 14 days or more on 3 occasions, and they go back to 2023, 2024. aggravated assaults, and lewdness, I give light to moderate weight. He is presently on probation, and it is a violation filed against him. So regardless of the court's decision, he will be detained to address that, and he's not on parole. Regarding the detention hearing matter, the court has become aware that he's a lifelong resident of New Jersey. He's went as far as the 11th grade, and he did attend counseling at Agape, and he does attend IOP and attend NAA meetings, anger management. But based upon the reasons set forth on the record, this court will be finding at this time, by clear and convincing evidence, no amount of monetary bail, non-monetary conditions, or combination of monetary bail conditions will reasonably ensure defendant's appearance in court when required, the protection or safety of any other person in the community, that defendant will not obstruct or attempt to obstruct the criminal justice process. I will grant the state's motion for pretrial detention. He's still to have no contact to RT until it's established it's been dismissed the restraining order, and also RT will come before a judge to address that matter. Until then, a violation of a no contact condition shall result in one or more penalties and consequences. Regarding the violation of monitoring, the court's going to find by preponderance of the evidence there was a violation of monitoring on those aspects. He's on level 2. I am going to consider some arguments made. There's a family dispute, and I did consider D1, but it hasn't been established that it has been actually dismissed against DR, and RT has not come before a judge. So I'm going to deny the motion to revoke. He'll continue on level 2, but he has to address these matters before Judge Ryan, who has the detainer for the probation. So if he addresses these matters, this matter could probably be revisited. His next court date with Judge Ryan is October 31st. If it could be brought up, that's fine. And there's still a no bail VOP lodged against him. Anything further by the state?
Nothing further, Judge. Thank you.
Anything further by defense?
Nothing further, Your Honor. Thank you.
All right. Mr. Lake, that concludes your matter at this time, and address all these issues before Judge Ryan with your violation of monitoring, and maybe they'll have the dismissal from RT, and these matters can be revisited. But at this time, you're detained until that's done.